Sky News reports that Prince Harry has been ordered to pay £48,447 to the Mail on Sunday by the 29th of December. This is for his failed bid to have struck out the defence by the newspaper in his libel case against Associated Newspapers Limited. But I wanted to do a very short follow-up video on this. I will link a video that I did previously which explains this case in a bit more detail when the judgment came out a few days ago. But this follow-up video is because I've already seen at least one news outlet saying that the court is, I quote, upholding the defence in this case. But that is not quite true. What's happened is the court has refused to strike out the defence, meaning the case must go to trial, meaning all of the issues, both the claim and the defence, will be heard at trial. So the court has not made any findings of fact at this stage, and the court was quite clear about that both in the press summary and throughout the judgment. So in this case, the court has just refused to strike out the case or to provide summary judgment, either of which would have meant that the case would not need to go to trial. However, the case is now set to go to trial sometime in 2024, unless, of course, the parties can reach a settlement in the meantime. What the court did say at paragraph 62 onwards of the judgment is that it is not fanciful that the defendant newspaper will be successful at trial in demonstrating that the public statements issued on the claimant's behalf sought to promote the judicial review claim as his battle against the government's perverse decision to refuse to allow him to pay for his own security. There is a real prospect that the defendant will succeed in demonstrating that this was a misleading description of the issues in the judicial review claim, arguably promoted because it was hoped to show the claimant's claim in a positive light, whereas a portrayal of the JR claim as the claimant trying to force the government to reinstate the taxpayer-funded state security, risked his appearing in a negative light. I anticipate that at trial, the defendant may well submit that this was a masterclass in the art of spinning, and, the defendant argues, it was successful in misleading and/or confusing the public. The resulting media coverage relied upon by the defendant did indeed characterise the JR claim as the claimant's challenge to the government's refusal of his offer to pay. Drawing those points together at paragraph 63, the court said, if the defendant does establish these facts, then I consider that it has a real prospect of succeeding in demonstrating also that an honest person could have held the opinion that the claimant was responsible for attempting to mislead and confuse the public as to the true position, and that it was ironic given that he now held a public role in tackling misinformation. And as a result of that analysis, in paragraphs 64 and 65, the court dismissed both the application for summary judgment and the application to strike out the defence, saying essentially for all those reasons in the court's judgment, the defendant's honest opinion defence has a real prospect of success. Now, many people might be surprised by the costs involved, almost £48,500, but this figure won't be the least bit surprising to many lawyers, because there'll be a number of different lawyers of various grades at various hourly rates working on this case for many hours indeed, all of which culminating in both paperwork and advocacy in court arguing for this application. But as the court has now ruled on that application and ruled against Prince Harry, the ordinary cost rules will apply, which includes interim hearings such as this. So it is not always the case that all of the costs are decided at the very end of the trial. If there are interim hearings, interim applications, the court can make an order for costs at the end of that hearing, deciding whether or not the application was successful, and loser generally pays the costs. There's also a mistaken understanding that I've seen in some of the comments that the UK taxpayer is paying for all of these legal costs for Prince Harry and each of his legal cases. That is obviously not the case, particularly in this case, because this is his own case against the newspaper for a case of libel for an article they wrote. But for more on that, I will link my previous video in the description below. You can go and watch that as well. But I just wanted to clarify the point because I've heard it more than once now that the court has upheld the defence of honest opinion. That is not quite what the court said. The decision of the court in this application is effectively that there is a real prospect of successfully defending the claim on that defence, not that the court has made a finding of fact that that defence will succeed. So I hope you found that useful. Please do subscribe if you'd like further updates from me on this, as that really does help my channel grow. Thank you for watching, and I'll see you next time.